because it's important for you to know if you're headed into a lawsuit or a divorce that you may not have complete control about how your case will resolve. You may think your case should resolve by agreement, that you're being reasonable, but if the other side assesses it differently, they think you're being unreasonable, or if they think they have nothing to lose, then you may end up in trial even if you're correct in your assessment that your case should have settled. Another reason I bring this up, and I repeat myself a lot about settlement versus trial, is because they're very different skill sets in the work that it takes to work up a case prior to trial that includes settlement negotiations and mediation, and then trial itself. Trial is a different skill set. It is about communication, persuasion, and presentation skills. Those skills apply during negotiation, but there's a lot of paperwork, motions, and briefing and correspondence in litigation before trial that obviously does not take place during trial when you're in a courtroom and witnesses are on the witness stand. Another reason why I make those distinctions between settlement and trial is because law school doesn't teach us that, and law school doesn't teach us how to try cases. So there's a huge population of lawyers that we deal with every day who know how to litigate. They know how to file motions, they know how to send letters, they know how to send a lot of emails, they know how to bill, they know how to paper up a case. We call them paper tigers, but ultimately they don't know how to try a case. They can't put their money where their mouth is. So I want to distinguish between those kind of lawyers and tell you about the lawyers that you should watch out for. And I'm going to qualify that by saying this. You can't take anything for granted. You can't take anybody for granted. Even if your case involves a lawyer on the other side that everybody knows has a reputation for maybe being lazy or not being thorough, doesn't have attention to detail. You never know when they're going to step up their game or why, what motivates people, and they may put on a good case. That's just a reality. So I'm speaking in general terms right now about two types of lawyers. The first type of lawyer is the most common one, and it's the one that can be the most upsetting to deal with, and that is the paper tiger or the litigator. All right? So they are going to use a lot of big words, and they are going to literally and figuratively point fingers. They're going to call names whenever there's a hearing in court. They make the case about the lawyers rather than the litigants. They're going to say things like, Mr. Bundy clearly doesn't understand the law, and make little head motions and things to inflame the case and to push your buttons. And they're very good at it. You have to have some perspective to be able to recognize what's happening and what's not happening. I'm going to read you some examples. This is a part of an email that was sent to a lawyer in my office. I want my discovery today delivered in hard copy. Her objectives and tactics chosen to achieve those objectives are disingenuous. That's an email from the opposing lawyer talking about our client. And then in another case involving an injury to our client, the defendant had denied liability. So we sent them a simple discovery request. Tell us your reasons for denying liability. And this is what the defense lawyer said. Objection. Overbroad, unduly burdensome, premature as discovery has just begun, seeks information protected by the attorney-client privilege or the work product doctrine. So what they're telling us is we deny liability and we're claiming that the reason for our denial is covered by the attorney-client privilege, so we're not even going to tell you. And our clients get this information. They see these emails. They see these letters. What does this mean? Do they know something that we don't? How do we defend against this, right? And then even in court, you'll see that lawyer who will stand up. They'll wave their arms really big. They may get up on their chair, throw papers, jab in the air. They may say things that you think, wow, I don't think that's true. Or they'll say things about the lawyer and make it about a case between the lawyers rather than the facts of the case. And that can be really disconcerting. What do we do? Why are they acting that way and you're not? What's the difference there, right? Well, I'm going to tell you about another kind of lawyer who, when I walk into court, he extends his hand and shakes my hand, says, hello, Aaron, how are you? And the lawyer who, when we send discovery requests to, we get a complete set of answers with no objections. And the lawyer who never sends an email saying your client did this or your client did that, or I'm going to do this to your client if this doesn't settle. That lawyer, that quiet, polite lawyer, is a very dangerous person. And here's why. That lawyer is not afraid of trial. That lawyer doesn't need to use these inflammatory paper tiger tactics to try to intimidate people into a settlement, because that lawyer has assessed the case. They're not afraid of the evidence. They'll give it to you in discovery. They may give it to you as a voluntary disclosure without even getting a discovery request from you, and they're going to announce ready for trial, and they will kick your butt if you don't watch out. I can tell you a couple of stories about those guys. One, when I was a very young lawyer about 15 years ago, my buddy called me. He was on the insurance defense side. He represented companies who injured people. And on behalf of his client, the corporation, he had sent discovery requests to a plaintiff's attorney asking for evidence to support the plaintiff's claim. And he called me to tell me, Aaron, those responses weren't due for 30 days. That's the law on discovery. But we got their answers in less than 2 weeks. And they didn't have any objections in them. And all the responsive documents, the exhibits in response to discovery, they had numbers on them, exhibit stickers, as if the guy was ready for trial. And it was clear to my friend, and it was clear to me on that phone call, that plaintiff's attorney had been ready to try that case before he had even filed the lawsuit, and was ready to go even early in the discovery stage. And without sending a threatening letter, a menacing email, or a nasty phone call, he had sent a message to my friend, I'm ready for trial and I will try this case, and I've got the goods to win it. And that case settled favorably for the plaintiff. Another story is a lawyer I know in town, quiet, unassuming. He's not on the billboards. He doesn't throw things in the courtroom. He doesn't yell at the judge or his opposing lawyer. Really unassuming gentleman. I sent him discovery requests in a case that I had against him, and just a few days later, I got a complete set of discovery responses back. No objections in it. All the documents I had requested, he produced. And I told my client, watch out. They're looking and thinking about trial. This isn't a case where they're going to have to run up a big fee on these baloney objections because they're afraid to try a case. This guy's ready, and he's getting ready for trial. And then the third is another lawyer in town who is a fellow of the American College of Trial Lawyers. He is legit. And whenever a lawyer goes up to him and jabs their finger in the air or tells him, sir, your client, he is a bad person, he is violating the law. This lawyer, his reputation is he acts as if you're telling him the biggest secret in the world. And he nods and he says, I'll look into that. And he will. He will check on it. And then he will get you in trial. And he doesn't engage in those tactics. So you have to have perspective about what the lawyer is doing and capable of doing. If you're ever called in to sit on a jury, the judge will give you some instructions. And one of those instructions is that what us lawyers say is not evidence. We get to put our spin and perspective and interpretation of evidence to judges and juries to help them see the evidence for what it means. But what we say is not evidence. We're not witnesses in the case. We're advocates. We're a mouthpiece for our client in our side of the case. So you have to know that what we say when a lawyer files a motion or writes a letter, at best at that point, it is a wish list for their client. It doesn't necessarily mean anything other than it does give you a signal about what they may say in court. So you need to look at it and assess it for its truth or partial truth or its complete untruth and be prepared to defend it and address it. But that doesn't mean that you're saying, oh, this is true, it's valid, or this is what they're going to get, this is what the judge is going to do. It does not mean that necessarily at all. And watch out for that quiet, unassuming lawyer who doesn't engage in these blustery, flowery objections, because that lawyer is working on their case for trial and they're not afraid of trial. So do not take them for granted.